Committee's oversight inquiry into the Road Accident Fund. Please be informed that by law you are required to answer fully and satisfactorily. All the questions or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or to imprisonment for a period not exceeding 2 years. Mr. Harban, you've indicated that you would like to take the oath. If I could please ask you to raise your right hand so that I can administer that to you. Please repeat after me. I swear that the evidence I shall give.
I swear that the evidence that I shall give
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
So help me God.
So help me God.
You are now duly sworn in. Thank you, Mr. Harban.
Thank you.
Thanks very much, Mr. Ibrahim. Mr. Harban, I'll hand over to you. And once again, remember the acronyms and the like. Then we'll be friends. We'll be big friends if you remember that. Thank you.
Okay, thank you, Chair. I'll remember that. And thank you very much, Chair and committee members, for giving us the opportunity. We appreciate it. And I've noted this guidance. What we've done is, in order to summarize the issues that we've raised in our submissions, I've prepared a presentation which I'll go through it in half an hour. The presentation in words was sent to the Secretariat yesterday, but in order to demonstrate the points, I just left the text out and used pictures. But what we'd like to do in brief is just give the committee a view from the perspective of the road accident fund the victims. And secondly, explain who the LPWF is and how it got involved in this. And then just lastly, address issues related to the litigation that the LPWF has embarked on. And I'd just like committee members to take time to think about who the real victims are in this matter. For current purposes, I'll refer to a Sipho Zwane. It's not his real name, but there are many Sipho Zwanes that I can show you in the cases. So we'll say Sipho Zwane from Manguzi in northern KZN. I can't take the other part of KZN, the southern part, because I see that there are many of us that are from there. So just to avoid bias, we'll say Sipho Zwane from Manguzi, KZN. A 10-year-old boy who has suffered brain damage in an accident and has waited for more than a decade to get compensation. That's the person whose interests we need to look at when we look at the whole issue around the RAF. And from time to time, when I explain even the cases, I'll refer to Sipho Zwane. It's not his real name, but as I say, there are many Sipho Zwanes. When the LPWF launched its review application in respect of the Board Notice 271, when we launched it in November 2022, we already had been notified of 200, just over 200 claims that the RAF had refused to accept based on the relying on the board notice. And just to pause to explain what to accept. Accept doesn't mean that the RAF is going to accept the claim and say, yes, we are liable. That's to get somebody's claim on the desk. So it's relied on the board notice effectively to shut people out at the door. And I'll explain how that has impacted victims and how it impacted the LPW. We must recall that many of these victims have little or no education. They are indigent and they live in rural areas. I can also show, if necessary, where that was highlighted even in the LPWF's review application, even in the judgment. And they haven't been compensated and are waiting for a long time to be compensated. Know the reality of South Africa. It's difficult for anybody to be injured, whether it's in a road accident or in any other injury, and to be disabled But it's even worse when one is from the rural areas. That person is in even a greater predicament than somebody who's from the urban areas. And then also when it comes to litigation, some of these claims drag on for very long. Some victims, unfortunately, pass on while waiting for compensation. That's if they ever get it. And it's almost a second blow to them because they never get justice. And I must state up front that it's not our view that the RF should accept every claim that comes across its desk, every spurious claim. We are also acutely aware of the risk of fraud in these matters and the risk of people submitting unmeritorious claims. You have drivers, and I'll give, these are actual examples from matters we deal with. A driver driving a horse and trailer on the N2 at 5 in the morning, and he has an accident and claims that there was another vehicle. There was no other vehicle. Or somebody in Ivory Park in Gauteng driving on a Friday evening after having a few drinks and hits a fence and claims that he had a claim against the RF. Those we don't want. We are also not here to protect lawyers. We don't speak on behalf of the legal profession. There are other people who do that. We are here to look after our interests and those of the victims. And it would be rather burying our head in the sand if we were to say that there isn't the risk of fraud or that people don't take chances with unmeritorious claims. So just to explain maybe at that point who the LPWIF is and what the LPWIF does. We do what is called professional indemnity insurance. It's called malpractice insurance. So if we go back to Sipho Zwane. So Sipho Zwane has...
Sorry, Mr. Harban, can I just ask?
Yes.
So because this is being streamed,
yes,
so we can hear you in the room. So when the mic is... when you do this, then the guys outside who are streaming can't really hear. So the sound keeps doing that. So I don't know if you're able to move the chair a little bit this way or the mic more towards you. If we can, try and do that.
Is this better, Chair?
Yeah, much better. Thank you.
I apologize for that. But just at this point, just to explain what, as I said, the LPWIF does professional indemnity claims. It's what's called legal malpractice. So in order to avoid an acronym, in order to avoid jargon, if we take Sipho Zwane, having been injured in an accident with his head injury, and then Sipho Zwane's guardian goes and approaches an attorney to submit a claim against the RAF. If the attorney accepts the mandate and doesn't do it within the 3-year prescription period, for whatever the reason, or lodges the claim within 3 years but doesn't issue summons within the additional 5 years, Sipho Zwane's guardian has a claim against that attorney, and that attorney will report the matter to the LPWIF and then the LPWIF, because the attorney has failed in their duties to Sipho Zwane's mother and to Sipho Zwane, and therefore that the mother will have a claim, and then the LPWIF will pay that claim as the insurer. It steps into the shoes of the attorney, and in looking at the claim, it will step into the shoes of the road accident fund as well. That's one example.
May I ask, so can you just explain the prescription in the context of the road accident fund? What it means, what are the time periods, and therefore why would a claimant then lodge so that people can understand the context of Sipho Zwane complaining about the attorney?
Okay, thanks, Chair. The prescription period for an RAF claim is 3 years from the date of accident. That's to lodge. That's the first part.
So prescription. So if I'm sitting at home, prescription is meds that I'm getting.
Yes.
Right.
Okay. All right.
Explain, please be patient with us. So explain prescription. The committee members know that's not the issue, but we're also doing this for the public. So we're trying to make it accessible, if you know what I mean.
Yes,
Yeah.
I understand, Chair, and excuse me because I just can't find the English words at the moment. But in that part of the world where I come from, people will say "Icala alibol," so a case doesn't rot. But in reality, the case rots. The case has got a 3-year lifespan, and after that, the 3-year lifespan, it rots. So, if I can use that analogy, so an accident today. The victim has 3 years to lodge their claim with the RAF. If they don't lodge it within the 3 years, and then they are barred by law. So their case is rotten, if I can keep using that analogy, to lodge within the 3 years. But the RAF Act says that after you've lodged your claim form and all the supporting documents, you then have an additional 2 years to issue summons if your claim is not settled. So that is how it works. So in Sipho's Wane's case, either the attorney didn't lodge the claim and the claim form and the supporting documents within the 3-year period, or even if he lodged it in the 2 years after that, they didn't issue and serve summons on the RAF. Hope that clarifies that aspect. So, in addition to the issue of prescription, which, just by the way, prescription is the largest risk that the LPWF faces. I think it's more than 60% it's about 55% of the number of claims, but more than 60% of the value. In addition to that risk, the other risk that's related to RAF claims is that of undersettlement. So Sipho's Wane's attorney does everything on time, and let's say, for example, the claim was worth 1.5 million. The attorney, in order for whatever reasons, decides to accept 300,000. Which is inadequate to compensate Sipho's Wane. Even in that case, Sipho's Wane, through his guardian, has a claim against the attorney. So to use my example, because the attorney only took 300,000 rands for a 1.5 million claim, the LPWF will have to pay the other 1.2 million. So that's why we also have an interest in undersettled claims.
Okay, so in other words, I'm just going to simplify this. So you have 3 years in which to lodge a claim. So for hit and run, it's 2 years. For anything else, it's 3 years. If you don't submit a claim within those periods, then you can no longer do so. That is prescription, right? So that's the first thing. But if the attorney then lodges on time, let's say within the 3 years or immediately at any point during the 3 years, then there's a further 5 years.
No, it's further 2 years.
A further 2 years.
2 years, yes.
There's a further 2 years over and above the 3,
yes,
in which the matter has to be finalized. If the attorney does not go to court to pursue the matter because the 5 years is coming up, then if that 5 years expires, the RAF no longer has an obligation to process and pay that claim. Is that what you're saying?
Yes, not the attorney go to court within the 2 years, that the attorney serves summons on the RAF.
No, I get it.
Yes.
So in other words, you've got to take a legal step to make sure the claim stays live. Okay? That's the first instance. So then Sipho's Wane's parents can say, but you should have lodged, you should have gone to court. You didn't. It's your responsibility. And that attorney comes running to you guys and says, Sipho had claimed 1.5 million. The thing is prescribed, so my insurance needs to pay Sipho. that money. So that's the first case. The second case I hear you saying is that if the lawyer settles with the road accident fund at 500,000 rand, but Sipho's family feels that it should actually have been 2 million, then that family can also come to you and say, but our attorney settled for an amount that's too low. We want you to investigate it because the insurance should pay the difference between the 500,000 and the 2 million. Would I be correct in saying that?
Partly, with respect, Chair. What will
Please,
happen
yeah,
is the
correct
family just need to, even if they just write a letter to the attorney and say, and just to use layperson's language, you handled our case incorrectly, and therefore you are liable. That's all they need to do. The attorney brings that letter to the LPWIF, and then it's the LPWIF's problem. Yes. Thanks, Chair. There are certain things that the LPWIF is not. As I said, we're not here to speak on behalf of the legal profession, and also I know that theft of RAF payouts is a huge problem in South Africa. That is a matter that's dealt with by a separate entity, the Fertility Fund. Overcharging, there's what is called overreaching, but it's just people who take more money in fees than they should. That's a conduct issue that must go to the Legal Practice Council. That is not covered by the LPWIF. Our point, Chair, is that two wrongs don't make a right. So the current situation that we find ourselves in in respect of the RAF is that you have the Sipho's who are injured, but Sipho's mother can't even get her file on the desk of an RAF official. It cannot be registered, which is a problem. And as I indicated that a lot of victims will unfortunately pass on, others will just give up, because this law is a huge monster, particularly for the poor and the indigent. So, just a few points sorry, Chair, I just need to make about the LPWIF. It's important to note that we are a non-profit company. So the company doesn't have shareholders. So we don't have shareholders looking to get a return on their investment. Secondly, the company is funded by the Fertility Fund. That's where we get our money. The attorneys don't pay for this insurance. But every attorney that has a Fertility Fund certificate is automatically covered. So as long as you have a Fertility Fund certificate, you're covered. So you don't have the situation like insurers will say, you're not covered because you didn't pay your premium or you didn't renew it on time. And when we deal with these matters, whether it's prescription or whether it's under settlement, we have to step into the shoes of the RAF and assess the matter as the RAF would have done. The essence, just before I go into the board notices, there were, just to explain that as well, there were two board notices. There was first board notice 58 that was issued in 2021 and with an RAF form. There was a matter launched in order to review that board notice. That's the Mautla and others versus the RAF and others. That matter was successfully reviewed, and then the RAF withdrew that board notice 58, and then it came with another one, board notice 66. But those matters were dealt with in the Mautla matter. Then came these board notices, just before I go on to the second one. added a whole list of requirements that claimants had to meet in order for the RAF to register their claims. And since 2000 before that, since 2008, there were in 2008 the minister passed regulations for what claimants had to meet and published an RAF claim form. These new requirements that came with the board notices asked for a whole lot of additional documents that would be very difficult for people to meet. I'll just highlight two. One is if you have a death claim, if people have a death claim, they had to get a copy of the inquest report. I'm not aware in South Africa, Chair, that inquests, if there's an accident today and somebody unfortunately passes away, that the inquest will be held in 3 years. I don't know in how many instances that is possible. So if the person didn't have the inquest report, they were out. Secondly, and also looking at the South African context, they also wanted a VAT invoice from the funeral parlor. In reality, Chair and committee members, I don't know how many funeral parlors, maybe there are, the big ones are registered for tax, but usually these are also informal businesses. And how are funerals funded? Usually family members contribute, or maybe there'll be some sort of a funeral scheme that they would be a part of, and you get the money. Or sometimes you buy the funeral parlor offices as a package. You pay for the coffin and you get everything else. So all these just examples of how disconnected the board notice requirements are to the reality of South Africa. And if you didn't tick every box with the board notices, if you've got 19 out of the 20 requirements, you are out. And that means that your claim, you haven't interrupted prescription, so you're in trouble. Sorry, Chair.
So can we just walk through the board notice? What did the board notice say? And so that we can then understand the effect. So you say they issued a board notice. So the board notice is effectively, I'm just trying to help us get through so the public can follow. So the board notice set new requirements for submitting a claim, so the documentation that you must provide. Some of that, for instance, so the Road Accident Fund pays for funeral expenses, and you have to provide proof that you paid for funeral expenses. That's what you're saying. So basically, the requirements for submitting a claim were increased by the board notice. Can you just talk to the key changes in those requirements so that we can then follow why it was difficult for people to claim? Yeah.
Thanks, Chair. And I'll just summarize it in 3 tranches. First of all is what it required in respect of the plaintiff, the person submitting the claim, what it required in respect of their mandate to their attorney, and then lastly, in respect of quantifying the claim, that's how much they would pay. Plaintiffs had to submit, for example, in the case of children, unabridged birth certificates, and other documents relating to their identity, which I understand the person needs to prove who they are. They had to submit documents relating to proof that they were involved in the accident and the accident was reported. Then they had to produce documents if it was a represented claim in respect of the mandate to the attorney, and whether it was a contingency fee agreement, and whether the contingency fee agreement complied with the Contingency Fees Act. A contingency fee agreement is where the attorney acts in a matter would and will get paid if the claim is successful. So they'll get a percentage. The cap is 25% or double their rates. So that's it. And then also, in order to get paid, the claimants now had to the attorney had to submit. This is not SIPO's one. This is SIPO's one as attorney had to submit a tax clearance certificate, and also in order to get into the door. The SIPO's one is attorney and SIPO's one is mother will have to go and get medical legal reports and actuarial reports, and these cost money. And you are spending the money before you even know that the RAF is prepared to look at your claim. It would be difficult for unrepresented claimants, or what are called direct claimants, to meet all those requirements. It's very difficult for attorneys who specialize in this type of work to meet those requirements. How much more difficult would it be for somebody who's unrepresented, who's poor, who's rural? I don't know whether there are any neurosurgeons and actuaries that are operating in Mangus in northern KZN. And you can use the same analogy for different parts of the country to access these people who need to write the reports for your file to get onto the desk. It costs a lot of money, and a lot of people wouldn't even know what those are, these opaque requirements that you had to meet. And the board notice went against a series of judgments, because judgments up to those like Busuku's had set out what they called substantial compliance, just to get your claim in the door. I keep emphasizing that. And the board notices effectively increased that. The board notices were issued by the RAF with a corresponding form that was issued by the Minister of Transport to amend, in effect, the RAF Act and the RAF regulations, which is not possible. You cannot amend legislation via a board notice. And when these matters, one of the issues that came up in the challenges in respect of the board notice is that the minister provided a record of the decision that was made on, because that was asked for. But that record of the decision, I think it's annexure TMH5 to my affidavit, is effectively says that the board notice was passed in order to resolve, because there was conflict between the RAF and the ministry. That very record that said that it is provided indicates that there was doubt from the ministry's perspective in regard to this. And secondly, you'll see from the last page, the handwritten part, where the ministry's officials also indicated that there should have been public participation. And when these board notices were issued, there was no real public participation. Interested parties were not invited to come and give comment, and they were passed. So we have had 2 board notices, and both have been successfully reviewed. But when I say successfully reviewed, we've had 2 full benches. So in 2 cases where there are 3 judges, and a whole list of others with single judges that have ruled against the RAF on each occasion on the respect of the board notices. Despite that, the RAF is persisting on its litigation. It's now appealed to the Supreme. It's appealed to the SCA, the Supreme Court of Appeal in Bloemfontein in respect of the board notices, and the LPWF is opposing that. But just a few things in that regard that's just relevant to the committee's terms of reference. The RAF is, in our view, pursuing unmeritorious litigation. The RAF is going to the Supreme Court of Appeal in order to defend a decision of the Minister of Transport, but the Minister of Transport is decided to abide by the decisions of the court. Secondly, it's in our view, Chair, with respect, it's fruitless and wasteful expenditure. The RF is just spending money to defer liability that will end up on its books. For example, the LPWF has spent about 2 million rands in respect of this matter thus far, and we don't know how much of that 160 million rands in corporate legal services of the RFs relates to this litigation. In the interim, the CPOS ones of this world are still left out in the cold. Their claims cannot land on the desk of an RAF official and be registered because the RAF is saying that it's still relying on the board notice. When the RAF litigates on these matters, while it's waiting for the SCA, it has raised several points. For example, in the Western Cape, it argued that all matters related to this should be held in abeyance. Judgments should be held in abeyance, waiting for the judgment of the Supreme Court of Appeal. The court here in the Western Cape ruled against them. On that matter was argued on the 5th of September. Judgment was handed down on the 7th of October. I can give the committee copies of all these judgments just so that they can verify what I was saying. We've had another one on the 29th of August in the Free State. The same point. 15th of August in the Northern Cape High Court. That's the same point. So the RAF is losing these matters. And Chair and committee members, if you want to fight a matter and you want to fight it seriously, you instruct your lawyers properly and you go and fight it. What happens in these matters? For example, in the Western Cape on the 5th of September, the RAF's legal representative filed documents. They brought the matter to court on that point, but did not even show up on the day. The RAF's legal representative was in the in the courtroom next to the one where the 5 matters were set down for hearing to deal with this issue. That's just one example. If I can take you through all the cases that on the issue of these board notices, where the RAF's legal representatives and other cases come to court and then they say that they do not have instructions. But why would I raise a point and say that point must be dealt with by the court needs to answer that question before it gets into the merits of the case, and then I don't properly instruct attorneys. So that's and something else. It means that when these orders go against the RAF, it's against the RAF with costs. So more public money is going to be paid to the plaintiffs' attorneys. And then, so that is the position insofar as the board notices are concerned. We don't know whether this matter, the issue will be taken up to the Constitutional Court. If it were to go to the Constitutional Court, we anticipate that we'll do, from the LPWF perspective, it will cost us 3 million rands in costs. I don't know what the RAF's costs will be, but looking at just the 2 full bench decisions and all the multitude of decisions around the country on this issue, I would, with respect, don't think there's any merit in the continued fight. Just one last thing I must say, Chair, because my time is running out, is that you mentioned hit and run claims. In 2019, the LPWF launched an application against the Minister of Transport and the RAF in respect of the hit and run regulations, because it's 2 years. And our claim was based on, we brought the application in respect of minors and people with head injuries. That's your SIPO's one is of the world. And the court ruled in the LPWF's favor, finding that the 2 year period for hit and run claims, insofar as children or people with head injuries are concerned, is unconstitutional. The RAF did not appeal that judgment, so it still stands. Despite that, the RAF persists in raising that point against claimants. A lot of people do not have the resources to go and fight it. Some attorneys report those matters to us, and it's not yet a claim against the attorney, but we've spent money advising them on how they should overcome it. The last matter that I'm not aware of in that case is a judgment on the 9th of June 2025 in the KZN High Court in Maritzburg. That's referred to in paragraph 82 of my affidavit. Just to give you an indication of I don't even know what the appropriate word is to use. The plaintiff in that matter, in paragraph 82 of my affidavit, suffered a head injury on the 27th of July 2007. His claim was lodged on the 1st of February 2010, a curator appointed 7th of October 2014. On the 9th of June this year, the court ruled against the RAF in respect of the prescription point, because they said that this was a hit and run claim and it didn't lodge it within the 2 years. I must mention that was a passenger. So it's 18 years later. We haven't even gotten into the merits of his case. And the point the LPWF wants to make with that is that we keep raising the issue that we had judgment in our favor on the 2 year prescription period, but you keep raising it. And the RAF strategy from where we sit is to raise it, and then always a day or two before the matter is supposed to be argued, they withdraw it. And what we do, because of being involved in that type of litigation for so long in respect of that 2 year prescription period, our suspicion is that the RF just doesn't want another judgment against them. And when we ask RAF officials or tell attorneys to ask RAF officials, why are you still litigating on something that has been ruled against you? And they say that they haven't been informed about it. And we say to the attorneys, give them the judgment. And then give them the judgment. And then they say, no, we're waiting we need direction from the top. But in the meantime, they're litigating on that issue. They're still shutting the SIPO's ones out from getting their claims onto a desk and getting their claims registered. And the injustice continues. So, Chair, sorry, I see that my time is up, so I'll pause there. Maybe the other issues I'll address in the questions and answers.
Yeah, so I'm happy to indulge you with 5 more minutes. If there's something that's really important, I do need you to clarify, because I didn't think maybe it came out as clearly. So in your affidavit, you have explained that the majority of the claims against you are about prescription. In other words, I do need you to explain to the committee what actually happens in practice, right? in other words, why do you believe the RAF is at fault for the matters prescribing, if you know what I mean, without the attorney running to court, or at least beginning a legal process in order to interrupt the prescription? I just need you to just explain to us, or if there has been a spike over the years. Has it always been the case historically throughout? Has there been a spike at some point? And if so, you know, what your experience has been. So I do need you to just cover that that ground.
Okay. Thanks, Chair. Prescription has been a problem since the LPWF was formed in 1993. Must say up front, not all the blame can be placed on the RAF. Attorneys sometimes just don't deal with matters timeously. They don't pay attention to matters in that where they've accepted instructions, do not lodge on time or do not issue summons on time, and that is the problem. And what became a problem for a particular focus for since 2021 is when the RAF came with these new requirements in respect of that are set out in the board notices and in the new forms. It would be more difficult for people to collect all the documents to meet those requirements and get their claims lodged on time, and thus interrupting prescription. These new requirements are very onerous. They're very expensive to meet, and unless you meet, if you use my analogy of that there are 20 requirements, unless you can have all 20 at once, you are going to have a problem. And if you don't meet them as a lawyer, the claim is going to prescribe in your hands. The client will have the claim against you, and that is part of the problem.
Okay, so what is the prescription period in the first instance, just to lodge? It's 3 years.
3 years, yes.
Okay, so what you are saying is that because we did cover this with the IT people from the Road Accident Fund as well as their claims people. So if you don't have, so the form moved from 12 to 24, 25 pages. So you need to have all of the specialist reports paid for, ready, and you submit everything. If there is one document that is missing out of the many documents that are needed, your claim won't even be registered on the system.
That is correct, Chair.
Okay, so what you are saying, I'm just trying to get in a concise way too. So what you are saying is that the matters you deal with, some of them fall in that category where the period runs out before the attorney and the client have been able to collate all the information or to the satisfaction of the Road Accident Fund.
Yes, that's correct, Chair. And in some cases, people collate the documents and they meet all the requirements. But when they get to the RAF, they keep getting turned back. I think that if we were to take an example of the matters that were argued in Cape Town on the 5th of September, the RAF kept rejecting, and the attorneys kept sending back the same documents, and eventually they were. In other instances, and I know this has happened in Gauteng, the attorneys actually go to either served by sheriff or they go to court and ask the court for an order to go. But just when we look at the 3-year period, we must always remember that somebody that's injured today is not going to instruct a lawyer today. They may not know that. Board notice needs has been reviewed and set aside, so it doesn't exist. So we cannot keep relying on something that in law doesn't exist because it's been reviewed
Okay,
and
but
set aside. But
you won the court case. Sorry if I'm just trying to get the court case was won. So when you say ongoing litigation, is the RAF appealing now? Is that the story?
Yes,
Okay.
the RAF is appealing, and that's the.
Okay, so essentially we're still dealing with the board notice that you refer to that replaced the 2008 regulations. It's, as much as you won that case, we're still dealing with it. There's an appeal.
That's correct.
Okay. Now, thank you. If I could then ask, when an attorney is basically responsible for the claim prescribing, I think you talked about that in the example that you made. So if the attorney is responsible for the prescription, then there is obviously that claim against the attorney, and I suppose that's where the fund comes in. But what happens if the claim prescribes in the hands of the road accident fund?
And that is a question we've also raised, the Honourable Dugmore, because there are direct claims that people lodge them, and then the RAF cannot issue summons against itself after the 3-year period. In fact, the Gianni matter, that's in the last two lines at paragraph 85 of my affidavit, that is what happened. That was a direct claim. No attorney involved, and the claim prescribed in the hands of the RAF. A curator was appointed later, and when she litigated against the RAF, they decided to blame an attorney, and they've lost on both points. So that is also our question. Claims prescribing in the hands of the RAF, and also what happens if claims are undersettled by RAF staff.
So in that case, in 85, the victim again was the loser, basically.
Yes, and then we assisted with the litigation, and he was ultimately successful, but many years later.
Okay. So thank you. And so in your understanding, can a prescribed claim sort of at the RAF, which then prescribes, can it, in your view now, given that case, can it be reviewed?
It will be very difficult for these victims to review matters. These are victims of direct claims. That once you've lodged your claim, I know that there's a lot of debate about whether the RAF has some sort of duty towards, in addition to its statutory responsibility, whether it has a duty towards direct claimants, but it's an area of law that I wouldn't want to speculate on now until I actually look at a case and try and understand what it is. But it's still a risk.
And then, you talk about the board notices, and you compare that to the regulations of 2008. So in what way, in your view, do these board notices make it more difficult for someone to institute a claim and so on, compared to the 2008 regulations? Why are they more difficult? Could you just summarize? You mentioned something like 20 criteria or whatever, but in summary, what is easier about the 2008 regulations compared to these board notices?
In the 2008 regulations, you knew what you need to get together. You need to have documents related to the accident. You need to have your statutory medical report.
Suggesting the board's notices were deliberate to try and make it more difficult. Is that something you would suggest?
Yes, I would. And I think that's actually what the RAF said. It didn't say that it makes it more difficult. They accused attorneys of submitting what they call skeleton claims. And or the skeleton information is the term they use.
So the jury's out on the one hand. You could say the RAF was trying to tighten up and deal with abuse. On the other hand, by making it more complicated, they actually sort of almost blocking certain claims.
Yes, but I don't think it was dealing with abuse. It just lifted the threshold so far that effectively nobody could get through the door.
So would you say, I don't know how many more minutes, Chair, I'd forgotten to push my own time.
No, you've got another 6-7 minutes,
good.
so you're still good.
Okay. So are you really arguing that these notices of the board have resulted actually sort of in more uncertainty actually around the whole area of what is required? Do you think it's just sort of complicated and confused the situation? Would you say that?
Yes, it has.
So in terms of this fund, can you just explain the difference between your insurance fund and the Fidelity Fund, just for us who might not quite understand the difference? I presume lawyers pay to both of these funds. They pay like a fee or subscription or whatever. Can you just explain the difference?
Just at the last part, no, lawyers don't pay. I think it's, we've looked around the world, the South African legal profession is the only legal profession we are aware of that gets insurance for free.
Who funds? Who funds?
So let me start with the Fidelity Fund. The Fidelity Fund is funded off interest on trust accounts. So a member of the public pays a lawyer 1,000 rands as a deposit. The interest on that 1,000 rands goes to the Fidelity Fund. So that's where the Fidelity Fund gets its money from. The Fidelity Fund deals primarily with theft-related claims. So when trust monies are stolen, and to look for our subject here today, the RAF pays attorney A 2 million rands for Sipho Zwane's case. The attorney decides to steal partly or all of that money. Sipho Zwane's mother can claim against the Fidelity Fund. And then that's it. That's its primary function. Pay members of the public who have lost money or property because it was stolen by attorneys. The LPIIF, the insurance company, on the other hand, deals with let me call them errors that lawyers make. So not people who do steal. Yes, yeah, a lot of the cases are negligence based. So that's where we come in. And
can I just say, these lawyers that are found guilty of stealing, as you say, I know there's the Legal Practice Council, but in your, I mean, it's obviously the protecting the client's money basically is what the Fidelity Fund and the fund that you're responsible for can achieve. But what actually happens to errant lawyers who at least the funds cover the victims, but in your experience, the LPC itself, do they generally follow up on all these cases of theft and or negligence as the LPC itself?
They should, because people who steal have breached the ethical rules of practice. Also, when a claim is notified to the Fidelity Fund, when the first place where the client will go and complain is to the LPC, and say that attorney A received money from the RAF. I don't know, he didn't account to me, and I can't find him, or he's just not answering my call. And then the person goes to the Fidelity Fund. But it's the LPC's obligation in terms of the Act to deal with those errant lawyers. And they should also be, those are also criminal matters, and people don't, a lot of members of the public don't know that. If your lawyer steals your money, yes, go to the Fidelity Fund, but also report it to the police.
And could I just ask, do you know who funds the Legal Practice Council, the staff who work there?
I think it's partly by an appropriation from the Fidelity Fund, but members also pay subscription fees.
Okay, thanks. And if moving towards the end, could you just give me a sense? You mentioned there was this appeal now after the application that you lodged and that you won. What are the timeframes involved in, let's say, the likely timeframes? Do you have any set down date for the appeal to be heard? When, in your view, will this matter be concluded? And are there any friends of the court in this matter? Is it just the LPIIF fund, or has anyone joined as a friend in seeking to achieve what you are trying to achieve with this application?
Thank you. In terms of time frame, we are looking at probably the first quarter of the first court term of 2026, because we've written through our attorneys to the President of the Supreme Court of Appeal to ask for a date, and they said that we're looking at that. So in respect of the LPIIF matter, yes, there are certain friends of the court. There were people that applied, some to join as co-applicants, others as amici, so friends of the court. I just don't have the list here in front of me, but I can make that available.
Thanks. And then could I just ask, in regard to practitioners actually getting involved in assisting clients to submit these claims, the issue of the uncertainty which, in your view, the board notices have created, does that possibly contribute to explaining why, and I'm not sure if this is the correct figure, but a very low number of claims are actually registered currently? I don't know if you know the figure for the number of claims that have actually registered. So what I'm trying to get to, do you think this whole current situation of the RAF relying on the notices which they've published, do you think it actually increases risks for attorneys who are representing like indigent, vulnerable clients?
Honorable Dagbo, it does increase the risk for attorneys. Insofar as the numbers are concerned, I wouldn't want to offer an opinion on that until unless I have information to drill down. I watched the presentation when the RF spoke about how many claims they had accepted, but I think one needs more information than to speculate. But in respect of the uncertainty, you even have people now lodging duplicates in the same matter in the 2008 form and the new RAF1 form in order to do it. And that's when you talk about public hospitals, doctors are complaining that why should we fill in things twice? We are already stretched. So that's still an issue.
Your time is up, Honorable Dagmo.
Thank you. Yeah, that was the last one.
Was that the last one?
Thank you very much, sir. Thank you.
Thank you. Honorable Dagmo, I know you don't sit with us all the time, so we called the Road Accident Fund here in the first week. And they have about 430,000 plus claims outstanding. They go back any number of years. We asked them about the matter of prescription. They claimed in the meeting that they will not claim prescription on those claims in the event that they expire. But we need to verify that is indeed so, and the mechanism they have used in order to effect that. So that's the first thing. The second thing is we also asked them, and that's the acting chief claims officer. I asked a question. What happens if a claim is about to prescribe? Does the Road Accident Fund notify the claimant either directly or through their attorney? And they said no. If the claimant does not remember that their matter is expiring in a month or two, tough luck to them. That claim is gone. If the attorney also forgets to follow up and write a letter of demand or something, they go there to those guys. It's no longer the road accident fund's problem. So the chief claims, we can get to the transcript and share it with you. But anyway, so I just wanted to, because you don't sit with us, so they've said they will not claim enforced prescription. That's what they've said. We must now check. When they come here, must check that is indeed so. The second thing is they said, if you forget and you don't remind them, tough luck for you. You and your attorney. Bye-bye. Thanks. Honorable Bila.
Thank you, Chair. Good morning to honorable members, Mr. Harban, and all the staff members present here. I think I will use 50% of my time. The other 50% I will utilize it when we come back from break, tea break. Let me start with this very stupid question, Honorable Chair. It's not just a stupid, but very. LPWIF is a non-profit company. You said you doesn't provide services with the aim of achieving commercial gain or profit. How do you survive?
Thanks, Honorable Pila. We survive because the Fidelity Fund pays us a premium. Every year, the premium is to cover the expected claims for the year and the operational costs.
Oh, you are not paid by the victims of road accidents or the lawyers?
No, we are not.
Okay, thank you. The next question, you said you want to assist SCOPA in its oversight inquiry into the REF because the REF-related claims constitute a significant risk for the LPWIF. Can you briefly explain to us those risks that are being constituted to?
Honorable Bila, the main risk is that of prescription that I explained. So when lawyers do not prosecute RAF claims in time and the claims prescribe in their hands, and then the claimants, the CIPOs, one of this world, then claim against the lawyers. Or secondly, when the claims are undersettled, then that also becomes a problem for us, because when the claim prescribes, we have to step into the shoes of the RAF. We have to deal with it as if the claim was dealt with by the RAF. When a claim is undersettled, we also have to step into the shoes of the RAF and say, if this lawyer had done his or her work properly, how much should the RAF have paid? And when we get to that number, we have to give the victim that, because we have to put the victim in the position they would have been if the lawyer had acted properly against the RAF. So that's it. But thirdly, when it comes to risks of fraud or unmeritorious claims, it's also in our interest that those can be weeded out as soon as possible, because you get people that try their luck with the RAF, for example, and then the claim prescribes and the person didn't. Let me just give a simple example, Chair, but it happens often. So there's an accident. There was a driver and 2 passengers. I then find out that, hey, my friends lodged a claim against the RAF, but I wasn't in the vehicle. And when they started telling me that they got money, I decided that I also want to be a part of that vehicle. And then I go and lodge. Chair, I've seen this, and we pick it up. I decided I also want to hitch a ride on that vehicle many years after the fact. I go and see this lawyer, Mr. or Mrs. ABC. They lodged the claim against the RAF. The RAF says, sir, you are late. Your claim is prescribed. What do I do as an enterprising fraudster? I didn't sue my lawyer. And then those claims come to us. The RAF maybe not have, didn't need to even investigate the fraud, because the claim was late. And then we also see those. So You see, so it's on those three aspects. So.
Thank you so much. I hope it's our anticipation for all of us in this committee to see all the victims of a road accident being compensated by RAF. But because the litigation take long, that some victims died before they can get their money. What happened if Sipozwane die before he can compensated according to what happened to him on the road?
Unfortunately, Honorable Bila, a lot of Sipozwanes die with their claims. When it's dead, it's dead. Let's say that the RAF claim meant that it was going to provide for Sipozwane's medical conditions, requirements for the rest of his life, his future medical expenses. When he's dead, unfortunately, he dies with them. People, yes, there's, and I don't want to get too much into the technical legal issues. For example, if a claimant were injured today in an accident and they go through the process and summons is issued and there's litigation going on, when we get to what you call litis contestatio, if the person dies, and their children and the executor can take over because you passed litis contestatio, so the executor will take over, and at least the claim will go to their children. But it's difficult. Unfortunately, many people die with their claims. If I'm injured in an accident, my claim for future medical expenses only relates to me. When I go with my claim for future medical expenses. There are no future medical expenses to pay. I've unfortunately gone.
Okay. Thanks for now, Chair.
Honorable Pila, I'd like to inherit the part of your instinct that can time. So you said you're going to use half your time, and you actually used half your time. Unless you have a clock there next. You don't? Jeez. Okay. Honorable Nontenja, and then after you will take a break.
Thank you, Chair, and good morning to everyone. What problem was the full completeness condition of the RAF 1 form of 2022 intending to solve?
Honorable Nontenja, that's a question and it was one of the grounds of our review application, that the RAF was not able to, neither the RAF nor the minister have explained it. So I don't know. And that was part of our argument, that we don't know what the object of that claim form was.
Would you say the new form was or produced worse results than the previous one?
Worse results in what way?
Worse results in saying people were battling to understand the new form now, which we don't even know what was the purpose of changing from the previously used to the current one. I believe that there is a new form that now RAF was of the mind that it will cover. It will be more productive than the previous one.
Yes, people are really struggling. And they've struggled from 2021, they've struggled with the 2022 form. They're still struggling now because the requirements are really onerous. And as I've indicated, in order to cover themselves, you get people that fill in both forms, the 2008 form and the current form, and submit that. But as I've said, it has its own difficulties because particularly doctors in the public sector, and I truly appreciate their position, have to now do double work for everything because they don't know it's just a strain on multiple resources. But it's really confusing. We are in a grey area in many cases, floating without direction.
To your knowledge, was there a grace period or guidance notes and training provided to claimants when the new form took effect?
None whatsoever, Honourable Member, and if I can show you at the end of my affidavit that document from the Ministry of Transport, and just to remind committee members, this is what the Minister claimed to be their decision. This is what they filed in court. If you were to read
Sorry, can you name the annexure?
It's TMH5.
TMH5.
If I can just
Sorry?
get it.
It's an annexure E for the members on your bundle.
Just want to go to
okay.
the actual part where it's, to show that this is not something that I am saying. So it's page 9 of that document, of the handwritten part. So show that this is not something that comes from me. It's something that comes from the Department of Transport officials. It says that it would have been proper that the RAF 1 form was published for comments by members of the public prior to implementation. So that's...
What page is that?
It's page 9 of the...
Page 9 of the ministers. I just want to make sure all the members can. So there is something there. Is that the one to Minister Mbalula from Mr. Nwako Makaipia?
Yes,
that one.
Above the signature of the advocate Johannes G. Mahato, Chief Director, Road Traffic Regulation. That's it. So no training, no public participation.
Can I continue, Chair?
Yes, please.
Okay.
Allocate the minute you lost. I'll add it at the end. Thank you.
Okay. Were APP targets tested against reduced capacity and litigation strategy? If so, who signed off that they were achievable?
In short, I don't know, because the RAF, well, as I've said, the minister hasn't opposed these litigation except give us that document, but we don't know. The RAF has never come to say that in the litigation against us.
Say, why, according to your affidavit, do you believe that APP targets were unrealistic?
I did not mention APP targets in my affidavit.
Are you not looking at another in the... Yeah, I remember seeing that, but it was another witness who referred to APPs, I think.
Would you say the role that is played by your non-profit organization has assisted the claimants, the victims, in any way better than what the case would have been if they weren't directly to RAF?
I would think we have, because unlike other insurance companies, we have to look after the interests of both lawyers and members of the public. Since this company was formed, spent over 1.4 billion rands paying members of the public. if this company was not around, those members of the public would have no recourse. Just briefly to demonstrate the point, Chair, if you have a lawyer, sole practitioner, so one person in a firm, and a claim prescribes in their hand, and the client sues them, they may not have money to pay that client, which means that the client will be left out of pocket for the second time. Whereas, and that's where we step in, is that we'll pay the client. So I think members of the public have benefited to the tune of over 1.3 billion rands. I don't know what the figure is as at today, because this is growing every day, but it's surpassed 1.3 billion.
And how is your NPO getting compensated for this wonderful job that you are doing for the claimants? Because my concern is on the victims.
We are not an NPO, we are an NPC, so it's not a non-profit organization. So where do we get paid is by the money from the Fertility Fund. The Fertility Fund has to pay us a premium every year, and that's what we use to operate and pay the claims.
Chair, I think I will pause there, but I think the work that you are doing for these victims is commendable, sir.
Thank you very much to the honourable member for that.
Thank you very much, Honorable Nontenja. Shall we take a break and come back at 11:15? Thank you, members. Honorable members. Shall we resume? Welcome, Honorable Atkinson. Welcome, Honorable Kupeka. And welcome, Honorable Maduna. You do know that, Honorable Maduna, it's going to be your turn immediately. But I can skip you if you want to settle. And then, okay, I can skip you. Honorable Atkinson, are you staying or you're going to sit here? Ah, you're EFF today. You did. Okay, thank you very much and welcome back, Mr. Harban. So, Honorable Matlala, I think we'll start with you, then to Honorable Kupeka, and then we go back to Honorable Maduna and then Honorable Atkinson. Oh no, why? you know? No. So the reason, Mr. Harban, we are laughing is because last week he said, I know I'm not the chairman's favorite. and the next opportunity I get to redeem myself, I blow it. You know? I tell you, I am beyond redemption. I need help. Honorable Isaac.
Good morning, colleagues. It's all good by me, I promise you, no worries. I come in peace. Mr. Harban, thank you so much for being with us today and obviously enlightening us on the LPIFF. I've looked through the affidavit. It's pretty comprehensive. I was in part covered by my colleague, Honorable Dugmore. It's actually where I needed to start with, but he covered that. So my questions would be pretty short and concise. And I was assisted in formulating these. So what I'd like to figure out, and I'll go a little slow, is that in your affidavit, which as I said is pretty comprehensive, you mentioned that you've paid some 2,946 prescription-related matters between July 96 and September 25. So it's quite a protracted period of time, from 1996 to 2025, some 2,946 prescription matters. And the value of that was about 527.3 million rand, just over $500 million rand, right? Bearing in mind it's a very protracted period. So what I'm trying to figure here is, what in your opinion, sir, is the average value per claim paid? I was just, before you answer, I was just trying to figure it out, I'll tell you, because again, I emphasize, from 1996, there we go, thank you. From 1996 to September 25, 527 million. You could have had paid one claim out for 3 million. I don't know, you'll tell us. And then how much, if you want to scribble this down, sir, how much, if you can recall, is the highest single payment that has been made on prescribed claims specifically? Then I also have another question, but I think in all fairness, Chair, with your permission, perhaps we could ask Mr. Harban to answer that, and then we could move on to the next one, if that's okay. Yeah? Thank you.
Thank you, Honorable Isaac. On average, the claims we pay are, I think it's 600,000 is the average value of a claim paid. So also we must remember that it's not open-ended, the amount that we pay for claims. The way the insurance is structured is that it depends on how many partners there are in the firm. So sole practitioner will get 1,562,500, 1,562,500 rands, 1,562,500 per year. So if we have a claim, that's what the maximum will pay if it's a small practitioner. Because that's the amount of insurance they have. But on average, as I say, claims are valued at about 600,000. The highest amount that we would pay for a prescribed claim is 3,125,500, 3,125,500 rands. That's for big firms, because as you'll see in my affidavit, there's a schedule on the policy for how much we pay. But I cannot, off the top of my head, say what's the biggest amount that has been paid for a prescription claim. But it's information that I can ask my colleagues at the office, and we can provide it if necessary.
Oh, no, I don't get involved at all for the next 15 minutes.
Great. So, so in your, just to go back to that one, in your opening explanations and remarks, so SIPO that we spoke of, obviously would not have got out a lot of money by the sound of the numbers over this protracted period. I don't know, it's just my thought and opinion when you say an average is about 600,000 off the top. But nevertheless, that's just a comment. So
Sorry,
if you want to respond, that's cool.
Yes, if I can. When I said, Honorable Isaac, it's the average value of claims, it's the average value of all claims, not just RAF claims that we pay. That's 600,000. If you look at RAF claims, prescribed RAF claims in particular, and once again, my colleagues at the office can give me the figures right up to today, the average. But they become more expensive because, particularly if you're talking about head injuries and medical legals, future loss of earnings, future medicals, past medicals. So RAF claims do tend sometimes to be worth much more than the average. And as I say, that figure I can get from my colleagues at the office. It's something that is tracked very regularly to give you just. So if you're looking for Honorable Isaac, if you're looking for the average value of a prescribed RAF, average value of an undersettled RAF claim, can get that, put figures up until today.
Okay, that's great. If you maybe get the office to forward them to the team, it'll be interesting read actually. Cool, thanks. And then the next one is you also indicate in your affidavits that in addition to the capital paid, okay, the LPIFF also pays for investigation costs. Okay, so what I need to try and figure is, are these investigators are they permanently employed by the LPIF? And then what is the nature of the investigations that they would then conduct? But first is, are they employed by the LPIF? And of course, what is the nature?
No, Chair and committee members, they're not employed by the LPIF. These investigation costs are what other people in the insurance industry call defense costs. So if we get a claim and we appoint a firm of attorneys to go and look into the matter, that's what we call investigation costs. To see, if we're using the RAF, for example, whether there was an accident on a specific date at a specific time, whether the person was injured, and if so, is it true that is the plaintiff's version true that the other driver was negligent? The insured driver will look at that. Sometimes those law firms appoint people to go and do the investigation themselves, but the term investigation cost is really the defense cost. And they come back and they tell us that, yes, the accident happened, the attorney did take the mandate. And it's because sometimes, unfortunately, you get attorneys who take mandates, but when they get a claim, they deny that they ever had a mandate. But there's a file. Then our lawyers come back and say, no, but the person had a file, he just didn't pay attention to it, and we think you should settle. So rather pay rather than litigate. Or concede that you are liable and say to the clients, okay, we are liable to the plaintiff. What we need to look at is to investigate the amount of that liability, so how much the person would have gotten. So it's that type of work.
Okay, and then finally, Chairperson, is the LPIIF able, I know in terms of the system and the policies and being a non-profit organization, I understand that stuff, but is there at any point in time over this protracted period that for some reason or the other, the LPIIF was in a position to perhaps recover any monies that were perhaps paid out at a inflated price or incorrectly, or perhaps through any attorney? Is there any occurrence to that nature?
There's none that I'm aware of where money has been paid out so that they shouldn't or inflated. We have systems internally that deal with that. So a legal advisor that's dealing with the claim in our office is an admitted attorney with some practical experience. And if they look at a claim and they say that the claim is worth 700,000 rands, they prepare documents, explain what that is, goes to somebody else and someone else, it goes through multiple levels of checking whether that it is valid. So we certainly in the more than 16 years that I've been there, there's never been a claim that has been paid out that shouldn't have been. Or more money paid than should have been paid.
Awesome. That's a quality statement that we haven't heard in this committee for a long time. So, considering the HGSA reports, etc., that come through the committee. Chairperson, I'm done, and I thank you, sir, for your positive responses. Thank you.
Thank you very much, Honorable Isak. Honorable Matlala.
Thank you, Chair, and thank you, Honorable Isak. Greetings, Mr. Harban. Yes, I want to just establish a few things. One, which is what is the interest of the LPWIF in this process that we are engaged in? In just one line, I've read what's on your affidavit, but I just want to understand it from you, because you are not getting any money from RAF or from government. You are actually winning these litigations, which come at cost for RAF. What is your interest in this process?
Thanks, Honorable Matlala. Our interest is really twofold. One is the unmeritorious litigation. It's this case that the RAF is fighting that it has lost is against us. It's costing us money to fight that. Secondly, we see the amount of money that's being spent here, and we believe that it's fruitless and wasteful. But thirdly, there are victims that cannot, unfortunately, do not have the ability to come and speak about these things. The CPOs one is of this world. And we are fortunate because of the work we do. We've got a broad scope, broad insight. Thank you.
All right. You said that the the claimant whose case may have prescribed can write to the lawyers to say that they want to make a claim against them. I want to understand if there are other mechanisms, because from what you said, it would appear that Mr. Zwane or their family would say to Attorney X, we are writing to you to say that you have failed, and then rely on Mr. X to take that to you guys as an insurer. I'm not saying that Mr. X wouldn't, but is there any other way of claiming through you guys without relying on the very person who have failed to deliver in the first place?
Thanks. And that is a very important point that you raise, Honorable Matlala. Unfortunately, Mr. X has to report it. A lot of times, Mr. X thinks that they need more than that letter. In terms of the LPIF policy, you just need something where the client says, and the simplest of it is that one line, you missed my case, and they would report it. Unfortunately, you get Mr. X may decide to fight that matter, and a lot of times it's only when there's one family, they have gone to see another lawyer and have brought a claim against it and litigated against. Remember, they've already waited for the RAF. Now, years later, they have to sue the lawyer. And then sometimes you get lawyers that go and consult with an advocate, and the advocate says, but why didn't you report this matter to the LPIF? And these lawyers haven't. But even those, it is a huge problem. But even when if Mr. X comes 6 years later, unlike other insurers who would say, no, it's a late notification, so therefore you can't come. In our case, because we have to look after the public as well, so Mr. X come, we'll pay the claim and we'll deal with you later. So, but it's a problem. The first part of your question, the problem you raise, is one that there's no denying that it's a big problem, that we're relying on the person against whom the claim is brought to report it.
Okay, yeah, I think it is a serious challenge. But I want to also establish your relationship then with the LPC, because let's say now you have 20 claims around Attorney X, so, and you find them to be legitimate. What then becomes the consequence management, besides you paying off the claims? Or you only pay off the claims and you don't get involved in terms of ensuring that Attorney X adheres with a particular code of conduct and then prohibits this from reoccurring?
We won't report the matter in those circumstances to the LPC. We'll pay the claims, but we'll go out to Attorney X's office and sit with Attorney X and give Attorney X risk management education and tell them that you need to register your matters. We've got a prescription alert system, which is an electronic diary that's free. We sit with Attorney X and all Attorney X's staff and educate them on how you can, things that you should do to avoid a recurrence of this problem. Sometimes it's not even don't even wait for the 20th claim. Sometimes by the first claim, you see that this person is really in the dark. They need help. So you go and sit in their office and help them.
Okay, so you're saying that you don't get involved in consequence management, besides, that workshopping or counseling a person about how they're supposed to conduct themselves?
That's primarily. But if we pick up unethical behavior, that we'll report it to the LPC. We cannot sit on knowing about unethical behavior and not report it.
All right. We had officials from RAF here sometime, I think last week or the week before that, who said to us they are engaged in a program or in a project of contacting all outstanding claims, all people who have outstanding claims, including the ones whose claims have been have exceeded the time. Are you aware of that? So it means currently you wouldn't have on your table, if that is the case, cases of people who are saying my case has been thrown out because of the time frame, because Raf said they are contacting those people, they are contacting everyone to come through, including those people. Are you aware of that?
No, I'm not aware of that.
All right. Well, that is what if my memory serves me well, that is the information that was brought before us. I guess we'll test it against other people who are still going to come before this committee. Maybe the last part could be just to establish from yourself what are community engagement mechanisms that you guys have. I think you are playing a very critical role. You are not necessarily here to account to us. We clearly understand that. So we can't really ask other things except trying to link what you do with RAF. And I also understand that you don't only deal with RAF, you deal with everything that involves lawyers across different spheres where they may have not been able to deliver properly. But in relation to RAF specifically, what programs do you have to create awareness of your existence and the services that you offer, seeing that the issue of lawyers and RAF has been a pending issue over some time? Do you partner with RAF to go to do community engagements? Do you have a RAF of focused areas of community outreach and community engagement to create and build consciousness from the claimants so that they can be able to come on board? That will be the last question from me. Thank you.
A very important point that with respect, Chair, and we don't work with the RAF, but we work with the Fidelity Fund. And yes, we talk to lawyers to try and explain to lawyers who we are and what we do. That's one thing. But if we want to talk about members of the public, there are outreach programs that are run with the Fidelity Fund. I can think of we've now concentrating on the smaller towns. Done Welkom, Rustenburg, a few other towns, and I'm just thinking going forward, what we've got Ulundi, Mthatha, we've got Khayelitsha, those are the ones that just come that I can think off the top of my head. But to go out to communities with the Fidelity Fund, and people can come. People may say, I had a problem, to use your example, with Lawyer X. Lawyer X has never ever phoned me back. I don't know what's happening to my case. That may be a matter that must go to the LPC, so you tell them. Oh, Lawyer X, I don't know about my money that was paid to Lawyer X. That's a Fidelity Fund matter. The Fidelity Fund is right there to deal with it. Oh, but my child suffered brain damage, but the lawyer only paid me 50,000. It could be a theft matter, it could be an under-settlement matter, but we are all there. But it's something that we are continuing to work on, and that's why just off the top of my head, it's just Ulundi, Mthatha, Khayelitsha I could think of, but they are, and it's a matter that we really take it seriously in order to. Doesn't help if our mandate is to protect the public, but the public doesn't know about us.
Thanks, Honorable Madlala. Honorable Kupeka.
Thank you, Chair, and greetings to the House. Mr. Harban. Mr. Harban, I think you too, along with a few other witnesses that have come to this House, have shed grave light on a lot of misdeeds and mishappenings in the Road Accident Fund, and we thank you for that. I just want to know, firstly, that with everything that's happening at the Road Accident Fund, especially around the lawyers, the unnecessary legal costs that are incurred, the unnecessary litigation, and basically that whole nonchalant stance of anything that is legal in the Road Accident Fund. I just want to know who from the Road Accident Fund is supposed to give lawyers their briefs, or rough lawyers their briefs or their mandates, because it seems as though they find it very difficult to get a brief, and it seems as though there's no one who is specifically tasked to manage their costs. Do you perhaps have any idea what's happening there?
Chair, I have no idea what is happening internally, but in that case, in Mpumalanga, the Hlajwayo case, we filed an affidavit comparing how the LPWF works. The LPWF's case, number one, you do not give lawyers a blank slate to say that you can go and litigate for us from here to Kilimanjaro. You don't. You give lawyers a specific area to look at in the matter, number one. Secondly, lawyers must account to you, report to you on what's happening. Also, we have a tariff. So lawyers can't come and charge their normal hourly rates when it comes to us because we have a tariff. So those are the issues, and I think that was addressed in my colleague Mr. Kunene's affidavit in the Hlajwayo matter. It's attached to mine. But I don't know what the problem is at the RAF and why you have so much litigation where people say that they're not getting instructions from the RAF.
So basically, you two would not be able to tell us exactly who would be responsible for that, because that's what I'm trying to get to. I'm trying to understand that from maybe Chair, you two would be able to assist here, and apologies for bringing you in. I just want to know who from the Road Accident Fund has basically neglected that whole lawyer situation where lawyers seem to be just doing as they please, with no recourse whatsoever. I think Mr. Harban is too far out for him to tell us that, okay, this is the reason or this is the person who is responsible, because with so much money being wasted in as far as lawyers are concerned, who is responsible? That's what I want to try and understand.
So I'm speaking from memory. I think the witnesses that are coming tomorrow, one of them will answer you very comprehensively. So you can reserve that question for tomorrow. I think we've got two witnesses, right? Tomorrow. Yes, we've got two witnesses. One has deposed an affidavit. The other one manages the attorneys. That person, just note that question and be here tomorrow.
Okay, no, thank you, Chair. On to the next one. Mr. Harban, on the 4th of July 2022, the Minister of Transport published a notice in the Government Gazette without any prior public participation. I think you know about that one. This had negative consequences for claimants, and the LPWF brought the review application in the High Court in Pretoria against the Minister. I just want to know, do you have any idea why the Minister did not oppose the LPWF's application and why they did not participate in the litigation?
I don't know why they didn't oppose it or participate both in this litigation for the LPWF litigation for the Board Notice 271 or the previous one. But I think, and that's a point I made earlier, the RAF is effectively appealing to defend something that the Minister is not, a decision that the Minister is not defending. So that is also confusing. And just to clarify, Chair, if I may, just a question that's, I think, points that wasn't properly covered earlier when I answered questions. Even the current litigation, the RAF one, this new RAF one form has been reviewed and set aside many times. So that's out of the table. What we'll be looking at in the Supreme Court of Appeal, if that were is going to go ahead, is the board notice. But I think it's important that I just make that point.
Okay, thank you. I think the next question is, with the persistent litigation by the Road Accident Fund into to the issue where the Judge President of the SCA was involved, which was granted to the RAF on the 1st of November 2024. The effect of the decision of the SA president is that RAF continues to impose the new RAF 1 claim form on claimants with grave consequences. Would you perhaps have any comments on that one, specifically having that RAF 1 form being imposed on?
Yes, I do have a comment on that, and that is the issue that has also brought us here. That I don't know how many times it needs to be said that that form is, don't know how many people need to say that the form has been reviewed, it's been set aside, but it's still being used. And the effect of the president of the Supreme Court of the Appeals decision was just that they can come and address the court on their grounds of appeal because they were unhappy with the restricted grounds they were given in Pretoria. The court said, yes, come and address us on your grounds of appeal, and if necessary, be ready to get into the merits. Nowhere in that order does it say that did it revive the decision to set aside that form. And I've got a copy of that decision somewhere, which I can make available so that the committee members can see that.
Chair, the board notices, it says that the board notices make it increasingly difficult for lay people to submit direct claims at the Road Accident Fund. I think, Chair, we for a long time have tried to understand why it is not easy for people, or why it has not been made easy for people to submit direct claims at the Road Accident Fund. I think outside of Mr. Harban, of course, we need to be made to understand that since we know that this claim form makes it difficult for anyone to submit anything at the Road Accident Fund, we need to understand, firstly, why the insistence is there to carry on with this form. And then number two, we need to be made to understand why the executive has said on numerous occasions that now it's very easy to submit claims at the Road Accident Fund. Because then it seems as though the left hand does not know what the right hand is doing. They say it is easy, but evidence suggests otherwise, that it is not easy. So maybe we would need to find a way to understand that. Then just lastly, Chair, the FEN highlights that the LPWF has spent approximately 2 million on litigation regarding the board notice 271 and raises concern on the RAF's litigation costs between 1 April 2020 and 31 March 2025, including wasted costs due to inadequate litigation management and unjustified litigation, questioning whether the RAF's persistence in the face of numerous judgments against it on the same or similar grounds does not amount to fruitless and wasteful expenditure. On that one again, Chair, I think it's more a comment for Mr. Harban, because I think we are on the same board in that all of this amounts to fruitless and wasteful expenditure. What would your comments be there? Because this is just an utter waste of money as far as we're concerned. To you. And that's my last question, Chair. Thank you.
I think that is also sounds like a quote from one of our documents. So that's our view, but it's over and above that. I cannot see what rational point there is to continue spending money on something that you've lost so many times, and you continue to lose. That's number one. Secondly, the point that I raised earlier, that you raise a legal point to try and rely on this document, and then don't even show up in some cases to fight it. Or when your lawyers show up to fight it, they say that, sorry, we don't have the appropriate instructions. And these are not things that I'm pulling out of the air. Chair, I can, because I've walked this journey for so long, I can break it down, give you the actual cases where that has happened, so that the committee can go and verify it, these things. So you have the actual recorded judgments where this is.
Thank you very much. Before I come to you, Honorable Atkinson, so by way of navigating the document, so we need to make some determination when we've heard from everybody. But so last week, when Mr. Songelwa and Mr. Charakupa were here, they showed us a diagram. I think it's in paragraph 52 or 50, 51, 52, and also from paragraph 81 or 82 of Mr. Charakupa's affidavit relating to the accounting policy. The two appear to be linked at this stage. So the first prescription, so there were 3 stages, A, B, and C. A is the claims, basically is when an accident occurs, but the claim has not been filed. B is when the claim has now been filed in the road accident fund, right? But it's in process. C is the one that is in payment stage, okay? Mr. Harban says they deal with the 2 stages of claim, stage A and stage B. Stage A is when someone is close to the end of the 2 to 3 year period by which they must lodge a claim, right? If the attorney does not start the court process before the expiry, in other words, you've submitted the documents, but the road accident fund is not getting back to you. You keep submitting, it happens quite a bit that they keep asking for documents, okay? If in the middle of that process, the period, the 2 year period expires in the case of a hit and run, 3 years in the case of another a type of accident, the claim then prescribes. That claimant will then come to Mr. Harban here and say, I don't know what my attorney has been doing. They've been, the matter is prescribed now. We can't claim from the RAF anymore. So that's stage 1. Stage 2 is when the matter has been lodged, but the RAF has not yet made a decision, and the attorney does not go to court to start the court process. If the attorney does not file for a court order forcing the RAF to pay, because the RAF must also pay within a certain period, that claim also prescribes, in which case that claimant may then come to Mr. Harban again. So these two, the accounting policy issue, believe me, the reason it is of such importance to this inquiry is not for the theory of it. It's for things like this. It's also for the impact on claimants. It is also the reason why the ICMS system is also important. So the reason I was asking the chap from IT, whether, and the chief claims officer, whether the system sends an SMS to Mr. Kubek, who is a claimant, to say, hey, Mr. Kubek, your claim is about to expire in a month's time, right? So they said, no, we don't do that. If the claim expires, so what I'm trying to say is, no, sure, I mean, the people who claim 500 million, believe me, they have no problem. They go to a big law firm. Okay. The point I'm making is, so the reason tomorrow is also important is that the legal person will explain how the RAF is treating the cases that have actually prescribed or are prescribing while the paperwork is in their hands. You know what I mean? And Mr. Kubeka does not know. In the case of people's lawyers, they then run to court and they obtain, that's when you get the default judgments and that kind of thing. So what I'm trying to say is, if you were to read just those sections in the previous affidavits that we've got, they are in the spec that we've got. Just read those sections. They help us understand how we get to Mr. Harban's problem. And the way I understand his submission is, if you solve this A and B problem, then there will be fewer people whose claims prescribe. Because what happened between stage A and stage B is that the form grew from 12 pages to 20 something odd pages, 24, 25 pages. They're also annexed in that pack. Secondly, the Road Accident Fund said, you need to, on your own, as an ordinary person, secure all the specialist reports. If you don't attach them, then we will not even look at your claim. We won't even register it on the books. And we will not even design the system to keep the documents you've already submitted. So you submit, let's say, 10 out of the 11 documents. They won't keep the 10. They discard them. When you come back, you must bring the 11 again. So those were the issues we were canvassing that day. So what I'm trying to say is, just go back to those affidavits. In fact, we'll ask the team that, because this is going to be useful. So from Mr. Forget Sepo's name from Road Accident Fund and the IT guy, can we highlight the parts of their evidence in the transcripts, because we get transcripts, highlight them for the members. Then we take that as it relates to prescription. And then we deal with the process of claims as explained last week. And then we look at this. It's going to be very helpful because all of them are linked. The claims that are shut out of the system because you keep trying to send documents and you can't get hold of them, right, are the claims that end up with Mr. Harban, where a person knows they exist. So in other words, you couldn't prove that your uncle, Honorable Madlala, paid for your funeral, for your relative's funeral. And if you don't have something that says that, they reject everything. They reject everything while it's in the hands of your attorney. So all you know as a claimant is that your matter is in process. And then your attorney comes to you and says, sorry, we can't claim anymore. We're supposed to claim within 3 years. 3 years has expired. That's one of the reasons we're here. And at least when the senior officials come, we can then ask them, but how is this process helpful? Right, in the end, to the claimant and that kind of thing, but also prove to us you are indeed phoning these people who write to us, members. We get these. People say, I've been waiting 8 years. I'm sure you get, Honorable Kupek. Those are the people that, those who know Mr. Harban exists, they go to him. And they say, my claim is prescribed. My attorney has been telling me stories. Because the attorney then didn't go to court to sue the Road Accident Fund. The attorneys who sue don't have Mr. Harban's problem, in essence. So I hope that that makes sense. But I'll just ask the team if you can just pull various aspects and just send the attachments to them. I know it's more work, I apologize. But if we can do that, thank you. Honorable Atkinson.
Thank you very much, Chair, and thank you very much to Mr. Harban for appearing before us today. We really appreciate your affidavit and your information that you're giving us as well. I noticed in the affidavit you say that that your legal practitioner's insurance indemnity fund doesn't obviously receive, you don't receive your money directly from lawyers, but as a single premium from the Fidelity Fund. Around ballpark, how much is that single premium that you receive each year?
It's about 212 million in the last year. So it's a portion for claims, expected claims. There's an actuary does that and costs. So it's say it's about 185 plus VAT was just what was paid last year. I can't remember off the top of my head what is paid this year.
So how much of that single premium goes towards paying REF claims as a matter of interest?
Sorry, can you bring the mic a little closer?
I was just interested as to how much of your money that you receive from the Fidelity Fund, how much of what you pay out actually is related to the Road Accident Fund? What percentage?
About 60%.
60%.
Yes.
Okay. All right. Yeah, no,
60% is related to prescribed, and you're looking at about 5% related to undersettled. So you're looking at about 65% of our claims are RF related.
All right. And other non-RF related claims, what kind of other stuff do you pay out on as a matter of interest?
Conveyancing, litigation, those are the main types of matters, but commercial. But the four big claim types: prescribed RAF, undersettled RAF, conveyancing matters, litigation, and then I'll call it general prescription, so that's non-RAF
Yeah.
prescription. So people with claims against whoever, where the lawyers don't do it in time.
But the reason why I asked that question is I can see, obviously, RAF is becoming an increasing headache to you, because you mentioned the prescription claims that you've been going for, in fact, over a period of 30 years, nearly a quarter of all those claims have been paid out over the last 5 years, 125.78 million. So I'm seeing that it is becoming more and more of a problem, and actually potentially can affect your fund and your ability to effectively remain solvent as well. So this is yet another kind of bad effect of the road accident fund. It's actually sucking up a lot of your resources as well. The other line of questioning I'd like to bring to you, obviously here, you're only assisting people who come via lawyers, okay? So the Road Accident Fund made quite a big thing about the fact that they wanted to help people who were coming independently, who came directly to the Road Accident Fund, as opposed to coming through lawyers. And we were told that there was a great effort to do that, and then ultimately we were told by I think the media person that actually only 3% of all claims come directly from the public. However, 25% of all outstanding claims are actually direct claims. So in other words, anyone who comes directly basically doesn't really get their claim settled by the Road Accident Fund. So the point I want to make is there is no protection from you for people who come directly to the Road Accident Fund.
No, there is none, and so there's none, because there's no lawyer there involved who we have to step in for. But sometimes these matters come to us, I won't say it's indirectly, because so the direct claims, and that's, for example, in my affidavit around about paragraphs 85, 86, I refer to that matter, the Gianni on behalf of Lepole matter. That was a direct claim. Right. That the RAF turned around and said to the claimant, your claim is prescribed. And they had to litigate, and then they came to us, and we also had to get involved, because the RAF tried to join a lawyer that got involved in the matter later. So
yeah. Do you remember a time when there was much less litigation at the Road Accident Fund, and when people actually went to the Road Accident Fund and had their claim settled directly at the Road Accident Fund, that it was actually more rare for a matter to go to court? I'm talking about maybe 20 years ago. And at that point, I would assume you probably didn't get much in the way of claims from the Road Accident Fund. I'm talking about maybe the late 1990s, early 2000s.
Yes, there was I think I joined the profession in 95, the legal profession. Things were quite different there. Yes, there was the stage where they appointed agents of the insurers, but they, as a plaintiff's attorney, you had to be much more on your toes at that stage when you submitted a claim, when you litigated against the RAF. Usually, when the RAF said to you your claim wasn't valid, and they gave you a reason, and even if they didn't put it in writing, if they spoke to you and they said, Mr. Atkinson, your claim is not valid, you're going to have a problem proving negligence of the insured driver. You knew that that was where you were shaky, so that's what you had to do. Also, the RAF, for example, is in those days, you'd litigate, and then they would settle and say to you, okay, we accept that we are liable. And they would use a tender. They'd say, okay, you claiming R1 million, we're going to tender 80,000 rands for your claim. It put the attorney on risk, because if you weren't able to get past the 80,000 that the RAF proved, you couldn't get costs. So there was a different litigation model, and usually they'd settle with merits on you, so your eye is you're not thinking of quantum. But they were working on the quantum, and it wasn't an underhand tactic, but it was a prudent litigation tactic, that there was always more risk on the plaintiff's attorneys to be on their toes when you dealt with the RAF. So,
just going back to your comment there about literally 25% of all the prescribed claims happened during the period from 2020 to 2025. I mean, that really in a sense, and I think you probably make that quite clear in your affidavit, that's really all completely related to the legal board notice and to the legal documentation or the legal RAF forms that have come out of that, which really is effectively the period.
Honorable Atkinson, so the person who opens the door
Yeah.
is from the broadcast people.
Yeah.
That's why I'm such a nag about the microphone. So when
Sorry.
it's then they can't hear the.
All right. Okay.
Yeah, thanks.
Okay, I'll talk into the microphone then. Okay. So, yeah. So just going back to the point I made earlier about the fact that a quarter of all your prescription claims have happened over the last 5 years, and that effectively is the same period as you had those illegal board notices put in place. So that's in essence what's caused the problem, and that's effectively during the term of the most recent CEO as well. So I mean, he was the, I suppose, the person that wanted the accounting procedures changed to make things look more beneficial, and the one who kind of pushed the board notice in essence as well. So you would agree basically that one of the major issue of your problem here really is that illegal board notice, or the illegal board notices. I mean, that's the basis of your affidavit, isn't it? Yeah.
No, Chair. Just so to explain that those notified prescription claims wouldn't have necessarily have prescribed since 2021 or 2022. They would have prescribed before that.
Right.
But people would have notified us of them. So I don't think that we can just blame the board notices for that number. And also, Bas, place on record, I don't know what happens inside the RAF. It would be unfair and outside of why I was sent here if I say that, if I just go and blame the CEO of the RAF. We are fighting a principle against an organization, not fighting an individual.
Are you aware whether that I know that the minister has actually asked the Road Accident Fund to stop litigating about the accounting standards and about all the issues around this and the board notice. Are you aware whether they are continuing to actually use illegal board notices, or have they gone back to what they should be doing?
They're still using the board notice and the RAF form. They continue using it.
Okay. So in other words, the minister is really just allowing the Road Accident Fund to be administered subject to an unlawful board notice, as opposed to the RAF Act, which is actually what it should be, in essence.
Yes, I don't understand, with respect.
Yeah.
If the minister's decision has been reviewed and set aside more than once, why the minister hasn't, to use a colloquial term, pulled the plug on this thing, and why it's being allowed to carry on?
Because in essence, the minister is allowing a contravention of the law. That's in essence what's happening here. What, in your view, can be done to address the problem?
Number one, withdraw the litigation on the board notices. Number two, go in the interim, and as the court suggested in the LPIF case, go back to the 2008 and the substantial compliance regime. And then number three, allow those people who have had settled claims to register on the RNYP requested but not paid.
Not paid,
Yes, system. So you can do that, and I think that will assist.
Okay. Thank you very much. Thanks.
Thank you very much, Honorable Atkinson. Honorable Maduna, I come to you, sir.
No, thanks, Chair, and good morning to you, Chair, colleagues. No, I'm also not going to be long. I have just a couple of short questions. I think umbuzo wami oqala ngifuna ukuchecka la. Mhlambe in line with one of my honorable members would have asked. I halela la ku establish ababuthi I process le yo claim isebenza kanjani. I-process le lapho ethi khona umuntu cha angiseneme ngoloyo XYZ nakangendlela enze ngayo kangongoba umba wami sowugcine uba prescribe so ngifuna ukuthola leya process ukuthi nje kafuphi uyana ayiphakamise kanjani leyo nto ifika kanjani kunini.
Okay, ngiyabonga. So ubuza ngokuclaima ukuthi umele akawenzanga umsebenzi wakhe. Okay. All right ke baba. Into azoyenza ke lo umuntu olimele ngithi ngizosebenzisa i-example ka
Sorry, may I ask, Honorable Maduna, will you have a problem if he answers in English? Okay, I'm just thinking for the sake of everyone else, like Mzala next to you there. Mzala next to you there.
Okay, no, I apologize, Chair. But just as an aside, perhaps we need to have this conversation in isiZulu and in different languages so people can hear. I don't think that side of the world where we are from, somebody is sitting in Kukwini cannot understand, or someone sitting in Mhlangeni. So, but yeah, and I'll make myself available if we need that. But
thank you.
Just, back to the question. Yes, what will happen is the claimant, so the Sipos Wane's family can write a letter to the lawyer, and I gave the example earlier. Don't need to make lots of allegations. It is alleged that on about this date, blah, blah, blah. Say, Mr. ABC, we instructed you to assist us with our claim against the RAF, and you messed up the claim. So we need you to pay us the money that we should have gotten for the claim. Mr. ABC just reports them, sends us that letter, and we're going to ask for the file and so on, and then the matter is with us. If we see that there was really a valid claim against the RAF, that the attorney didn't do it when you shoot, and sometimes the attorneys are defensive and say, no, but this and that, we'll look at it. Remember, we are independent, and it's our money that's being used to pay. And we say, no matter how hard you can argue that you did things right, we see that there is liability on your part. We'll pay the claimant. So that's how it happens.
Ngiyabonga. Makwenzeka ke manje ummeli lo wami engalidluliseli lo litabo kunina. Nina imechanism ohlambe waphikayo lama cases.
Okay. George, no,
please.
No, Mzala, I'm simply asking that in case that the lawyer or the legal practitioner does not report to them that he has received a claim about himself, do they have any mechanism that they use to pick up these cases?
Are you being a translator now?
No, Mzala, please leave. Don't harass Honorable Maduna on his time. Please, Mr. Harban.
Yes. Thanks. I think that's the question that was also raised by Honorable Matlala, that unfortunately, unless and until the lawyer reports the matter to us, we won't know about it.
I'm raising this because majority of the people that you find, especially when it relates to rough cases, that is why even lawyers go or legal practitioners go as far as receiving the money, the case in case, using the money for themselves, don't giving the client the money, because the clients do not know what is happening, where are the cases in the process. So baningi abantu mhlonishwa abakhalayo baningi lokhu angempela uyabona nje thina la njengoba sila ku social media and so on kusina le inquiry abantu abaningi bakhala ngokuthi abameli bethu saxhumana nabo ngodaba lethu ukuthi cha ngalimali ngozini kanje kodwa ummeli akaza abuyele kumina nento engitshela ukuthi udaba soluma maphi sengisho ukuthi ewona ama cases amaningi ozowathola especially la RAF siyakubona lokho ngapha ama operational efficiencies aka RAF and so on but ama cases ozowathola especially kubantu basemakhaya abantu abathi ngalimali ngozini ethile angazi nobu RAF usangikhokhela nobu RAF esekhokhile ufika umuntu wasemakhaya engazi nobu ukhokhe malini for that matter uyabo so ingakho mawuyiniki impendulo yakho ngiyayamkela kodwa it leaves me very worried because ngiyacabanga ukuthi hlasimpe there's a very robust education that you need to do around the services that you provide because ngiyacabanga bekuyolekelela uba abantu bethu umuntu mayengasajabulanga ngelegal practitioner ubaba uMadlala akwazi ukuthi athumele kunina direct ukuthi cha ngisajabulile ngobaba uMadlala bese nina niyalithatha ke lo daba niyali investigate ngicabanga ukuthi lokho ingakho nama cases wenu engekho maningi kangakho ngicabanga ukuthi into nje le engicabanga ukuthi going back mhlawumbe into ekufunakala niyicabange yebo ngicabanga ukuthi that was one two bengifuna ukuchecka la mhlonishwa sengayehla nje akukuningi ngicabanga ukuthi I session yakho was more of an informative session than any other thing ngiyabuka iningi imali eseniyichithile especially nidila nezinto ezimayilana no RAF their board notices naloko now engifuna ukuthola ukuthi yini lenzima ngale formula ka RAF kade abantu befika the form has been expanded the form is impossible to fill for lawyers now sengifuna ukunderstand yebo for umuntu ofana njenga noMaduno umuntu nje wasemakhaya wake inkomini vele nganzima but for legal practitioners yini lenzima ukugcwalisa iform.
Thanks Chair. I need to translate my because I was listening in Zulu, so I need to now translate my answer.
I understand this process. You think in your own language, and then you quickly translate into
I'll
English.
Translate. I'll start with the form on Honorable Matuna. It's not a matter of just filling in the form. The form asks for a lot of information. It asks for supporting documents. It asks for you to even go and pay to get medical legal reports to submit the form. And I'll repeat to what I said because I think you weren't here at the beginning. That's not for the RAF to pay. That is to get your claim on the desk and registered. So you spend a lot of money and you go through a long process. It's not just a series of questions. So that's number one. Secondly, as I've already mentioned, I cannot emphasize any more than I have that this form has been reviewed, set aside. The process is just repeating itself over and over, and I don't know how much more it needs to be done. That appeal in the Supreme Court of in the SCA Supreme Court of Appeal that's brought by the RF is not going to revive a dead form. That's not the question before the Supreme Court of Appeal. So I think certainly a lot of all the people that I've spoken to, never met one person that has tried to defend it, except the RAF itself. So the form is dead. And I hope that answers your question. But just to ask yourself, why would a claimant who suppose one was Manguzi, his mother has to go and pay to get a medical legal reports and neurological reports when there are but you don't even know you're going to spend that money, but it's only to get it. And to use the chair's example, that if there's a list of 11 items and then they'll come and they'll say one is missing. So all your money that you've used is gone to waste. You are kicked back to outside. They closed you outside to use a direct translation of a saying that's used. So because of that one thing. But insofar as your first point was with communication, I take that, and one of the lessons or the suggestions I'm going to take back to the office, both to the LPWF and the Fidelity Fund, is that we need to increase those community outreach programs that we have. Because yes, we've done major cities, and now we are going to the smaller towns, but I think that it's something that needs to be increased. We need to go to more of the areas and tell people who we are, so people can have a one-stop shop when they come. And their question is whether they had a problem with the conduct of the lawyer, or they say they didn't hear, the lawyer stole our money. So the people that are responsible for paying the money, the Fidelity Fund, if the lawyer stole the money, let them answer, yeah. If we say that the lawyer didn't do the work in time, then it's our responsibility, and then we'll find a way.
No, ngicabanga ukuthi ngasilekelela kakhulu lokho mhlonishwa. Because ngiyacabanga ukuthi ke kodwa mhlambe going forward siseza lithola ithuba. Ngoba ngicabanga uba sike saxoxa isikhathi phambilini no LPC, and khona ezinye ze-statement abayibeka ezinganginiki ukuphumula mangilala ebusuku. Ngoba kufuna sivumelane ukuthi cha inkosi impela wona akhona amaloya okanye ama legal practitioners angenzi kahle, and asethanda ukuba ninganyana siyadliwa imali zabantu bakithi, umuntu wakithi aclaimelwe lapha akhokhelwe angazi noma ukhokhelwe, yabo. Bese ke imali ziyasetshenziswa, siyasiboneka abafowethu kuthiwa bathanda kakhulu ukujabula endaweni zokucisha umokoma lezi ngomnyama, lapho kwenziwa khona lezi zinto, yabo. So kubalekile kakhulu ukuthi nanoba ngabe umuphi umuntu opractice, especially because these people have practice numbers, they have an oversight, and there must be an accountability framework. Now lokhu nje kungiletha kumbuzo wami wokugcina. Akwenzeke manje baba ngoba you pay based on, or as in when a legal practitioner would have been on the wrong. Akwenzeke kube nesimo lapho enithola khona mhlambe sekwenzeka ukuthi mhlambe ngokuyinhloso kanye ngokungenhloso sekudefendeka yena lo obemela umthetho, ngoba nanku nibalekile ukuthi okanye nigwema ukuthi nina nigcine nibhadala. Ngicabanga ukuthi umbuzo wami ukugcina leyo around the issue of conflict of interest, and then mhlambe in line with that, I would want to check your relationship with the LPC. Do you make any determination on any other on any cases basing it on their determination of the outcome of their inquiries, obviously into, because these people report to them?
Okay, thanks, Chair. Honorable Maduna, just with the last part first. We are a separate entity to the LPC. But if, for example, let's say that an attorney went to appear before a disciplinary hearing, and the LPC found that the attorney wasn't paying proper attention to clients' matters and so on, and that came to our attention, and the attorney said, hey, the LPC wants to fine me because they say I didn't pay proper attention to matters. We'll look at those matters and we'll say, yes, but claims prescribed in your hands, so therefore you'll be liable. And then we'll pay those, so that will be done. And the second part, with regard to a conflict of interest, just Honorable Matuna, you weren't here when we were beginning, because I was explaining the difference between the two. I'm here representing the insurance company, and it's not a conflict of, and the Fidelity Fund that pays for theft claims is a separate entity. But we deal with mainly negligence claims. And when there's negligence, yes, we pay, because for that very reason that the attorneys negligent. We're not going to defend somebody for the sake of defending them. And sometimes it's a difficult conversation. Sometimes you tell attorneys that they're negligent and they insist that they are not. So we say that, no, we feel that you are negligent and we'll pay the claim. So I hope that addresses both of your questions.
No, ngiyabonga sihlalo.
Thank you very much, Honorable Maduna. He said he wasn't going to be long. He used his entire 15 minutes. It's always famous last words. I'll be short. Mr. Harban, I just have a few questions. By size, how would you categorize the law firms that end up with this prescription problem, underclaiming and so on? I don't know if you understand my question. Is it large firms that should know better, or is it, what size firms typically have this kind of problem?
Mainly small firms, Chair. And by small firms, I mean 1 to 6 partners. But those between 1 and 3 partners are where the biggest problem is. That's the biggest risk.
So in terms, do you have an idea, and you don't need to give us a specific number, by location between metro and other, towns? Is this a big city problem? Is it a small town stroke rural problem? In your experience, if you are able to make that determination?
I'll have to go back to the figures to do the proportions. But in terms of just overall numbers, Gauteng will be the highest because that's where most of them are. So, for example, I can't go say off the top of my head that there are 4 firms at Dutya and 2 claimed. That's, for example, I need to check, but just pure numbers. Gauteng, that's the highest number of practitioners, so they have. But it's something that I think we can do a breakdown for the committee if it requires.
I wish to tell the members that if Dutya as a whole has 4 law firms, it's a lot. So Mr. Harban is being very optimistic. Really? There is more. Anyway, anyway.
Maybe 2 after.
Dutya is a small town. Anyway. Okay. No. The reason I'm asking this is because, so one of the things that I think literally all the members of the committee are concerned with is that it's usually the small person who knows a lawyer in the local town and says, please help me with this, and they're not able to find an attorney with all the resources and the backup staff and the legal secretaries and all of these people who can do the work in the background and make sure that the things happen. Because what that means is that the people that end up not getting a attention or a benefit paid out by the Road Accident Fund then tend to be the most vulnerable in terms of access to knowledge, access to even knowing that you guys exist, first of all. So that's my thesis. If I'm incorrect, then you need to let me know. So that's the first concern that I have, and hence I'm asking all of these questions. So I'm just explaining why I'm asking the questions. The next question, and it's my last one. The next question has to do with the number of claims that are unresolved by the Road Accident Fund. They are north of 430,000 at the moment. I have a feeling, and please correct me if I'm wrong, that an impossible number of those fall into the category of people that would come to you, right, to say my claim is prescribed, right? My concern is, if all of those people knew that you guys exist and they exercise that option, that would bankrupt you. So can you make a comment on that? Because I'm then just going to ask you your thoughts on solutions and so on.
Chair, first on the 430,000 claims, yes, they'll bankrupt us because, as we've pointed out in some of the documents, and I don't know whether it's before this committee or one of the others, that this is an existential problem for us. If we took 10% of that, it would be enough to wipe us out. The LPIF sits with a balance sheet. This is a small insurance company. It sits with a balance sheet of about 2.2 billion rands. Doesn't take much to wipe it out. And if we got the notifications for those claims, even if before we even got to payments, I'm sure the Prudential Authority that sits as part of the Reserve Bank and the FSCA will come running to say, guys, you are an insurance company in trouble. So you see that both from a financial perspective, from a regulatory perspective, that's a problem for us. But on your first question with with regard to locations and the small firms, I just need to dig a little deeper into that, because there's another issue that we must take into account, Chair. It's not, if people are operating in Gauteng, they aren't only representing people in Gauteng. We've been seeing claims against attorneys run by firms in Gauteng when the claimant is sitting in Holy Cross in Flagstaff. And to some of those attorneys, I've asked, have you ever been to Holy Cross? And they don't know. And then I've asked myself, how do you sit in Holy Cross in Flagstaff but instruct somebody in Gauteng? So I don't know what system, and I don't want to get into therefore whether some people are traveling around the country and touting for these matters or what is, but something, if we need to just give those, that's information that I can ask my colleagues to compile.
No, thank you very much. No, I want to thank you, Mr. Harban. Your submissions are going to help us in many ways. At the end of this inquiry, we want to be able to make recommendations which help the system to function better and more efficiently. What we really want as an outcome, what the committee wants as an outcome, is that the process of lodging and completing a claim is as simple as possible. It doesn't mean it's open season. It's just simple. And the level of expertise that is required, the support becomes available as necessary. In other words, myself as an individual, or even that law firm from Dujo, where, clients are scarce, RAF is probably the only thing that's going to keep you afloat. Even that process, to the extent that attorneys are needed in that process, is also seamless. And there is a facilitation that happens throughout the system. What I pick up from your submissions is that we have to make sure in our further inquiries with management that there is a system in place to deal with the issue of prescription while the matters are in the hands of the RAF, at least, right? Because if we can solve that problem, we can then push to the attorneys what is the responsibility of the attorneys. Alternately, we can sit together. So the RAF has a responsibility and the attorney has a responsibility. But what I found disturbing is that on the RAF system, there is nothing to warn any claimant that your claim is about to prescribe. I just find it unconscionable. There must be something that sends you an SMS or a WhatsApp and say, you logged a claim, etc., etc. And maybe there is a process of condonation that kicks in. Maybe the RAF has got whatever problems. There's a process of condonation where the claim remains alive because the RAF has got its own difficulties internally, and therefore it's still dealing with them. But to simply use an escape that says the matter is prescribed, somebody needs a wheelchair, we don't care, that doesn't work for us. So hopefully we will get there. So this has been very educational because we are trying to also prevent the problem from spilling into other parts of the system. We are concerned about the court system in Gauteng. the civil role, right? Where if you enroll a matter today, they may hear it in 2030 in full, right? Which leads to everybody trying to put things on the edge and court, which just causes enormous problems. So out of this whole process, we're hoping we can just unwind those things and make sure that the entire system works properly. So I want to thank you for your explanations, for your affidavit, your presentation, and for simplifying the matters for us. And we will take you up as Parliament on the idea of educating the public. In terms of, we'll take you up on that, and that we're able to do it in different languages as well, so that people understand. I must tell you, before I started looking into the RAF, and I was an editor, I didn't know the LPIIF existed. So you can imagine for other people how, the level of access. So we will take you up on that, and I will make sure that it happens. And we'll have the Law Society here to answer for the lawyers as well. We've had the LPC here, the Law Society is coming to talk to lawyer issues and so on, and then we'll have a complete picture. So we'll get to deal with the malpractice issues as well. So I don't know if you've got any closing comments, any advice you have for the committee by way of what you believe can be a good solution that we propose either to the Ministry of Transport, or any advice for Parliament in terms of our own oversight as we do this work on an ongoing basis.
Thanks, Chair. I think that in terms of suggestions, it's what I've covered already. Number one, I think I'd rather, the RAF should stop this litigation on the board notices and dealing with it, and the way it has also handled and reported on its liability in respect thereof. I would go back, deal with the 2008 regime and that RAF form. I think that also from if the position of the legislature is that they're going to come up with a new regulatory model, I'll only be able to comment on that, and the LPIIF will only be able to comment on that when they actually see it. But I think from one of the lessons also from the LPIIF's litigation is that you cannot impose things on people, as was done by the minister and the RAF in this case, without having a proper consultation with the public. I think that if that was done with it, the 2021 board notice or the 2022 board notice, and submissions were listened to from all the stakeholders, I don't think we would be where we are today. But thank you very much to members of the committee for their time and for allowing us to speak. Thank you.
Thank you. Honorable members, are we good to adjourn? No remaining issues? Okay. Thank you very much, honorable members. We adjourn. We shall convene tomorrow. I think tomorrow is a long day. Yeah? It is a long day tomorrow. Unlike today. Honorable Gupeka looks worried. I thought you were ready. I thought you were ready to rumble. Now you look worried. Thank you very much, honorable members. Mr. Harban, thank you very much once more. They've taken enough pictures of you. You must have 65 now.